On Thursday, a federal judge in Idaho extended the temporary restraining order on House Bill 83, or the Idaho ICE Act. The bill would allow magistrate judges to deport undocumented immigrants who'd been taken into custody in lieu of prosecution under certain circumstances. The ACLU sued over that legislation in March. Also Thursday, Professor Geoff Heeren of the University of Idaho College of Law joined me to discuss the legislation as well as the recent revocation of student visas for 2 University of Idaho students. Thank you so much for joining us this week. How often do we see states try to intervene or have more of a say in the immigration process?
Yes, so there is a history of states attempting to intervene in the immigration process, really going back to the 19th century, at a time when states like New York and California were attempting to impose fees on passengers coming into the United States. And beginning at that time, the Supreme Court started issuing decisions in which it emphasized the importance of a federal role in immigration, and that the country needed to speak with a single voice on immigration because it touches on foreign policy, touches on foreign affairs, even on national security. And for that reason, it's really important that there not be 50 different immigration policies in the United States, that there just be a single immigration policy.
Now, more recently, we have seen other states enact legislation that has made its way through the courts. What's happened with those laws?
Right. So I think this recent trend, which is, as I said, kind of harkens back to earlier trends as well, started with Texas, with a Texas law, which is very similar to the Idaho law. And that law was challenged in Texas courts, rather in federal courts in Texas, and was enjoined by a district court, and that the state of Texas requested that higher courts stay that injunction. So in other words, the order that was stopping the law from going into effect, they requested a stay of that. The case went up to the U.S. Supreme Court. The Supreme Court very briefly allowed the law to go into effect for some complicated legal reasons. But when the case went back to the Fifth Circuit Court of Appeals, the Fifth Circuit ultimately denied a stay of the injunction based on its finding, or its holding rather, that the state of Texas was unlikely to prevail on the merits of its claim that the law was not preempted by federal law. And again, the issue here is one of preemption, and what that means, to put it kind of in layman's terms, is that the federal government has a very important role on this issue, and because of that, state laws that sort of intrude into that space are found to typically be preempted by federal law.
So just to be clear, that Texas law, after going through that process, in layman's terms, is not currently in effect.
Right. So it's been halted by court order. And we've seen similar laws also in Iowa and Oklahoma, which have also been challenged in the courts. And the courts in those cases have also enjoined those laws. More recently, the Trump administration has a different position than the Biden administration did, and they have, I believe, sought the dismissal of those cases. Originally, in those cases, the federal government was the plaintiff. There were sometimes other plaintiffs as well, sometimes organizations or individuals who were impacted by the laws. But the federal government under the Trump administration has, I believe, their position is they want to withdraw from litigation of that type. That being said, those decisions are still out there and may carry precedential force.
And it wouldn't be the first time, nor would it take much imagination to think that this might be on a collision course that ends up in front of the Supreme Court eventually.
I can imagine that an issue like this could go to the Supreme Court. The last time that the U.S. Supreme Court heard a major case involving preemption and state immigration laws was a case involving Arizona, and that was over a decade ago. So it's possible we could see this issue resurface in the Supreme Court.
Another issue that we and so many other states are keeping an eye on is the issue of international student visas being revoked by the U.S. State Department. As of Thursday, CNN reported more than 400 college students and researchers and professors had those visas revoked. And it's important to note that 2 University of Idaho students have had their visas revoked. You are not their attorney, nor are you speaking on behalf of the university. But generally speaking, do non-citizens have the same constitutional free speech protections as citizens?
Yes, they do. And that's something with quite a bit of history, too, that I think is actually quite relevant to what's happening in our current moment. As I think about what's happening right now, I think back to the first Red Scare after World War I and after the Soviet Revolution. And that was a time period when a lot of non-citizens were being rounded up during the so-called Palmer raids, put on by Attorney General Mitchell Palmer in conjunction with J. Edgar Hoover. And people were arrested because of their political beliefs, because of their labor activism and support for the labor movement. And many prominent activists from that time period, like Emma Goldman, were deported from the United States. There was a backlash to that. The ACLU formed around that time period. The Supreme Court ultimately issued decisions which led to a much more robust period of First Amendment protection, which is the period we're in right now. And when we get to the time of the McCarthy era in 1945, the U.S. Supreme Court considered the case of an Australian labor organizer named Harry Bridges, who is in deportation proceedings in part because of his labor organizing work. And the court made it clear that non-citizens like Harry Bridges had a right to free speech in our country, and that's been the law since then. And so the law is that individuals have a right to free speech, that non-citizens have a right to free speech. And I think that a number of the non-citizens who've had their visas revoked have filed litigation based on First Amendment claims as of this time.
Along those lines, how about due process?
Absolutely. And in fact, I would say that one of the clearest rights that non-citizens have in the United States is the right to due process. And provisions like the First Amendment and the Fifth Amendment due process clause don't speak in terms of citizenship. The Fifth Amendment due process clause refers to persons. And so it's clear that all persons in the United States have that right. Basically, in layman's terms, again, this is the right to notice and to an opportunity to be heard before your important interests or liberty are stripped away from you.
Now, along those lines,
go ahead. Sorry.
Along those lines, we don't know the specifics publicly of these 2 University of Idaho students and why their visas were revoked, whether it was because they wrote op-eds like we've seen the cases in other students. But if it was something similar, do these 2 University of Idaho students have any recourse to appeal their visa revocation?
So that's a complex question that involves the interpretation of some complicated regulations and also some complicated issues related to federal courts. But I would distinguish here between the revocation of a visa and the termination of what's called the SEVIS record, which is the record that the government maintains in conjunction with schools that sets out essentially whether they are in authorized status in the United States or not. The Secretary of State does have very broad discretion to revoke somebody's visas for virtually any reason. With respect to SEVIS terminations, there's more limited grounds for that are set out in the regulations. Somebody might also be put into deportation proceedings as a result of the revocation of a visa or as a result of their failure to maintain status. And in deportation proceedings, somebody could try to raise arguments related to the illegality of the termination of their revocation of their visa. Somebody could also file a federal lawsuit, as some people have done, and raise claims that the actions are unconstitutional, perhaps because they violate their First Amendment freedoms. And so that's something that I think we've seen is a number of the students who've had their visas revoked, or some of the LPRs, even the lawful permanent residents who have been put in deportation proceedings because of their political advocacy, have filed federal lawsuits and federal claims. And that is another possibility that somebody could take in this situation.
national media has focused a lot on how this affects students and university researchers, but should other immigrants like green card holders who have different conditions surrounding their legal status here, should they be concerned about what they're posting to social media or their other First Amendment activities?
So I would never want to discourage anyone from speaking and exercising their constitutional rights, but I do want to note that a couple of the most prominent cases, including the cases of Mahmoud Khalil and Yuncio Chung, both involved lawful permanent residents who had green card status in the United States and who were put into deportation proceedings. And again, my point in mentioning this is not to try to silence anybody, but to emphasize how much is in stake in these cases, because it's all the more important when immigrants, when non-citizens are when their rights are being limited, that those of us who are citizens in the United States speak out and make it clear that our rights are important to us. As Benjamin Franklin said, we have a republic if we keep it, and in order to keep it, we have to be prepared to exercise our rights to defend it.
Geoff Heeren, professor of law at University of Idaho School of Law, thanks so much for joining us.
Thank you.